A case that could change the way millions of Americans think about their constitutional rights has now reached the highest court in the land, and the reaction from gun owners, legal scholars, and everyday citizens has been anything but quiet. The Supreme Court of the United States has agreed to take up a new constitutional challenge tied to firearms regulations and the Second Amendment, and legal observers say this one carries real weight. Court documents show the justices will be examining whether certain state-level restrictions on gun ownership and carry rights hold up against the constitutional standard the court itself established in its landmark 2022 ruling in New York State Rifle and Pistol Association v. Bruen. That ruling fundamentally shifted how courts are supposed to evaluate gun laws, requiring that any modern restriction be rooted in the historical tradition of firearm regulation at the time the Constitution was written. And that standard has sent legal challenges rippling through courts across the country ever since. According to reports, this new case has made its way through the lower courts after producing conflicting decisions, which is exactly the kind of legal disagreement that typically draws the Supreme Court's attention. When federal circuit courts start reaching different conclusions about the same constitutional question, the court tends to step in to settle it, and that is precisely what appears to be happening here. Legal experts say the core question before the court goes to something millions of Americans care about deeply. Do states have the authority to impose the kinds of permitting requirements, waiting periods, and carry restrictions that have become law in places like California, New York, Illinois, and New Jersey? Or do those laws, when measured against the Bruen standard, cross a constitutional line? Gun owners across the country are watching this closely. Many have expressed concern that certain state laws have made it increasingly difficult to exercise what they see as a fundamental right, particularly when it comes to carrying firearms outside the home for personal protection. The debate is growing, and it is no longer limited to gun advocacy circles. Constitutional law professors, civil liberties organizations, and public policy researchers are all weighing in, and the range of perspectives is wide. On one side, Second Amendment advocates argue that the Bruen decision already gave courts a clear roadmap, and that state legislatures have been slow to follow it. They point to the wave of post-Bruen litigation that has challenged everything from assault weapons bans to permit requirements, arguing that the constitutional text means what it says and that individual rights should not be reduced to a bureaucratic process that differs from state to state. On the other side, legal scholars and public safety researchers argue that the historical analysis required under Bruen is itself deeply complicated, and that the founding-era record on firearms regulation is more complex than either side often acknowledges. According to reports, historians and legal academics have filed briefs in multiple gun cases arguing that 18th century America did have firearms regulations, and that context matters when reading what the Second Amendment was meant to protect. Questions are being raised in legal circles about how the current court, which has a strong conservative majority, will approach this case given the doctrinal framework it created just a few years ago. The justices who wrote Bruen made clear they wanted a consistent standard applied nationwide. Whether that standard leads to the outcome gun rights advocates are hoping for, or whether it opens room for some regulations to survive, is something legal experts say remains genuinely uncertain. Court documents show that the justices have received a significant number of amicus briefs from states on both sides of the debate, law enforcement organizations, civil rights groups, and constitutional scholars. That kind of broad participation usually signals that the court understands the stakes of what it is deciding. A ruling here will not just affect the specific law being challenged. It will set a precedent that courts from Maine to Montana will be applying for years to come. For ordinary Americans, the more practical question is what any of this actually means for them. Legal experts say the answer depends heavily on where you live. In states with strict gun laws, a ruling that strengthens Second Amendment protections could require significant changes to existing permit systems, carry rules, and certain restrictions on which firearms residents can legally own. In states that already have relatively permissive gun laws, the practical impact might be minimal. What makes this moment particularly significant is the timing. Americans are still processing the ripple effects of Bruen itself, which courts have been interpreting in inconsistent ways. Some lower courts have used it to strike down regulations that had been on the books for decades. Others have found ways to uphold restrictions under the same standard. That inconsistency is exactly why this new Supreme Court review matters so much. It is a chance for the court to clarify its own doctrine and give the country a more uniform answer. The public reaction has reflected just how much this issue touches something personal for a lot of people. Gun owners who carry for protection, hunters, sport shooters, and families living in rural areas far from police response often describe the right to bear arms not as a political abstraction, but as something connected to safety, independence, and long-standing tradition. At the same time, communities that have experienced gun violence argue that regulation is not about stripping rights, it is about saving lives. Both of those realities are present in this debate, and both deserve to be part of how we understand what is at stake. What the Supreme Court is being asked to do is not a small thing. It is being asked to draw a clearer line about how far government authority extends into one of the most specifically enumerated rights in the Constitution. That is a question the country has been wrestling with since before the Bill of Rights was ratified, and it will not be resolved in a single ruling. Here is what responsible observers are saying. Do not assume you know the outcome before it happens. Do not let anyone on social media, in cable news chyrons, or in partisan headlines tell you the ruling is a foregone conclusion in either direction. The legal questions here are genuinely difficult. The history is contested. And the court, even with its current composition, has at times produced rulings that surprised people across the political spectrum. What you can do right now is stay engaged with verified, credible sources as this case develops. Follow the actual court filings, pay attention to what legal analysts with real credentials are saying, and be skeptical of anyone framing this as a simple story. It is not. It is a serious constitutional question being heard by 9 justices who will weigh decades of precedent, contested history, and competing legal principles before they issue any decision. The debate is real. The stakes are real. And the American public deserves accurate, clear information about what is happening inside that courtroom and why it matters. Keep watching this one, because whatever the court ultimately decides, it will shape the legal landscape of this country for a long time to come.